Hello and welcome to the LLG Grapevine podcast. You're listening to Helen Bennett, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hello, everyone.
Well, welcome back, Dennis. It's been a couple of weeks since we met for the Grapevine podcast. Have you missed me?
Helen, do you need to ask? Indeed, I have. No Monday is the same unless we have the opportunity to share and exchange our thoughts on the topic of local government.
Well, very much so. And it's a busy week for us. We've got the LLG Spring Conference later this week. And I know many of our members and corporate partners are really looking forward to it. And of course, you'll be covering some of the highlights from the sessions, Dennis, in the bulletin next week.
Well, yes, that's right, Helen. And the big headline is, of course, reorganisation. And I see that's on the agenda. But there's also plenty of content in the Spring Conference of relevance to all our members. As I say, I've seen the programme, which I'll be following online, and I can see there's plenty for everyone. But let's get back to what's been happening in the news last week. Councils will now get powers to impose a delayed home penalty under the latest government proposals to encourage development. Developers face tens of thousands of pounds in fines if they slow down house building under new powers being granted to councils to deliver 1.5 million homes. Under government proposals, house builders will need to commit to a time frame for construction before they are granted planning permission and deliver annual reports on their progress. Those who repeatedly fail to build or sit on land could be fined with a delayed homes penalty or even blocked from future planning permission by councils.
Well, I was reading the comments that Angela Rayner made on this, of course, the Deputy Prime Minister and Housing Secretary. And she said that the government had taken, quote, radical steps to overhaul the planning system to get Britain building again after years of inaction. Of course, this is their buzzword, isn't it? Get Britain building. And she went on that saying that in the name of delivering security for working people, we are backing the builders, not the blockers. Now it's time for developers to roll up their sleeves and play their part. And she added that the government going even further to get the homes that are needed, and that no more sites with planning permission gathering dust for decades while a generation struggle to get on the housing ladder.
And the plans, which form part of a government working paper on speeding up house building, would apply to developments of 50 or more homes. Now, the prospective fines would be based on lost council tax revenue and could be imposed by councils on developers who fall at least 10% behind schedule without good reason. As a result, a developer who is failing to build 50 homes that would each raise £1,500 in annual council tax could face a £75,000 fine. This change would require new legislation and would only apply to future planning permissions. Ministers will also test a new requirement for developments with more than 2,000 homes to include a mix of affordable and commercially sold housing by default, on the basis that this could lead to faster construction. The government has introduced legislation to speed up planning decisions and boost house building by removing avenues for legal challenges and reforming the compulsory purchase order process.
Well, I recall that Labour committed in its manifesto to deliver 1.5 million homes during this Parliament, which ministers have admitted is a challenging target, I would say so. But the Office for Budget Responsibility estimated this spring that house building would rise to its highest level in 40 years and contribute to the UK's economic growth.
Well, indeed. And the government has already committed £2 billion for 18,000 new social and affordable homes, £1.29 billion for both the Warm Homes Social Housing Fund, £800 million in top-ups to the current Affordable Homes programme, and £2 billion for regeneration projects that the government says will add to the total number of available homes. And finally, a further £600 million will deliver training for new construction jobs. And it's been reported that Rayner is pushing for further investment in social housing as part of next month's spending review, which will set departmental budgets for several years.
Well, that'll be interesting, won't it, to see how much money, especially now there's all this, all these announcements over the funding of the military. So we'll see what's in the coffers. It is an interesting driver, isn't it, though, Dennis, for the completion of house builds. And we do know that developments can often stall. And I wonder whether this might inadvertently disincentivize developers. I mean, I'm no expert. I do know that planning permissions are down, according to the BBC, in the year end 2024. Only somewhere in the region of 30,000 housing projects had received planning permission, which it said was the lowest figures on record since 1979. So let's see. Now, I want to turn to our colleagues in Wales. Of course, tackling homelessness across both Wales and England is a continuing challenge, with numbers high and rising. But Wales, in an attempt to fundamentally address homelessness, has introduced a bill which it aims to transform its response. Now, this is the Homelessness and Social Housing Allocation Wales Bill, which the Senate states fundamentally changes the Welsh homelessness system. So it's focused on prevention and providing more tools to support people into longer term homes.
And the bill focuses on a multi-agency response to homelessness, bringing public services together to respond to the varied causes and the overall consequences of homelessness. The Welsh Government state that the response is rooted in evidence and the lived experience of those who have been homeless, and is a vital step towards achieving the long-term ambition of ending homelessness in Wales.
Well, the key elements of the bill include transforming the homelessness system in Wales so that it focuses on earlier identification and prevention. It also targets action at those most at risk, in particular providing the opportunity to end homelessness amongst young people leaving care. And it focuses on a multi-agency response to homelessness, bringing Welsh public services together to respond to the varied causes and consequences of homelessness.
And the Cabinet Secretary for Housing and Local Government, Jane Bryant, said that this bill marks a turning point in how Wales tackles homelessness. I'm proud, she said, to introduce legislation that not only changes systems, but will also transform lives. And the Secretary went on, I'm particularly pleased about what this means for young care leavers. By bringing housing and social services teams together, we'll ensure that these young people, who are our responsibility, get the support that they need.
Well, as always, England would do well to observe the impact of this bill when it becomes law. Now then, Dennis, we've had some lovely weather of late, and I know many of our members will be enjoying the parks around their communities. But a question has arisen about what public parks are actually for, hasn't it?
Indeed, it has. Very controversial. Differing interpretations of public access rights are at the heart of the Brockwell Park Festival case, pitting a campaign group against festival fans. The High Court has quashed Lambeth Council's decision to allow a series of festivals to go ahead under permitted development rights just a week before the first event was set to take place. Brockwell Park, London, is known for hosting festivals during the summer months, attracting thousands of visitors. And this year's first set of events includes 5 music festivals, the first of which was scheduled initially to take place on Friday, the 23rd of May. Now, Lambeth approved the May events using permitted development rights in March.
Well, a decision notice, I'll get there in the end, Dennis, a decision notice issued under Section 192 of the Town and Country Planning Act 1990 labelled the development as lawful, as it fell within the scope of the permitted development rights, which are contained in, is the legal bit, Schedule 2, Part 4, Class B of the Town and Country Planning General Permitted Development England Order 2015. However, local campaign group, and that's the group called Protect Brockwell Park, PBP, doesn't roll off the tongue, claimed that Lambeth's decision to grant the application for a certificate of lawfulness was in fact unlawful.
Indeed, Helen, I think I've got the easy bits here. The campaign group argued that large-scale live events in the park are unsustainable, that they disturb wildlife and compact the soil, and they also complain that the events fence off large areas of the park for weeks at a time. Now, in a judgment handed down by the High Court, a judge found Lambeth acted unlawfully and irrationally in issuing the planning certificate that the council relied on to approve Brockwell Live. The judge therefore quashed the certificate in relation to the Brockwell live events. And in a statement on the decision, a spokesman for Lambeth Council said, "The temporary change of use of land, including for events such as Brockwell Live, is permitted by legislation for up to 28 days in a calendar year." The judge affirmed the existence of these rights in court. And going on, the council said the new certificate application is for 24 days, and consideration of the application does not stop the events proceeding. But Helen, I see from the weekend news just gone that this dispute is now back in court as the campaigners feel that Lambeth have ignored the court ruling. And I'll provide more of an update on this in Bulletin 21.
Well, that's very, very interesting. I understand part of the issue was that the judge found certain parts of the park itself would actually be used for festivals for up to 37 days. I believe the festival has now happened, Dennis, and I think there's something, I think there's a final weekend coming up. But yeah, that will be very interesting to see what happens in court on that.
Indeed.
Now, turning to other news, the Law Society of England and Wales has published a protocol outlining the role, value, and ethical obligations of in-house solicitors, which it says is, quote, intended for board-level sign-off to ensure clear reporting lines, independence, and resourcing. The Law Society said the protocol clarifies expectations between the in-house solicitor and their employing organisation and represents its view of best practice for the employment of in-house solicitors. So the Law Society is recommending that the protocol is presented to what they call the central guiding entity within the governance structure of the organisation for sign-off.
Helen, the protocol sets out a number of commitments. Number one, the employer should not ask solicitors to act in a way that conflicts with their professional obligations. And this commitment must be included in employment terms, alongside the commitment to provide insurance and/or the costs coverage for claims and detriments suffered by lawyers in the proper fulfilment of their duties. And number two, the legal function is required to have reporting lines which empower it to advise the organisation directly and effectively on legal matters. Ordinarily, this will mean that the most senior lawyer must report to the most senior executive within the organisation, for example, the Chief Executive Officer or Managing Director. Number three, the most senior solicitor should have access to the governing mind of the organisation. Where the organisation has a board of directors, the solicitor should have access to board information, the option to attend board meetings in full, and an open channel, or where practicable, a reporting line and regular access to the chair and the most senior independent director, including one-to-one meetings on request. And finally, number four, the organisation should not seek to terminate the employment of the most senior solicitor without the agreement of the organisation's governing mind, for example, the board.
Well, the protocol also states that the legal function should be provided access across the organisation, which is something we advocate for, be consulted at an early point on significant projects, which is exceptionally important, and any programmes with potential legal implications, and have continued input into these projects and programmes at their discretion, including providing a view on whether or not a project has legal implications, and that the legal function should be granted access to the resources it requires to perform its role effectively, including staff proportionate to responsibilities, access to legal databases, technology, etc., funding for continued professional development, now that is interesting, and resources to engage external legal counsel on matters where the relevant expertise does not exist in-house. And finally, it says that the legal function, under the supervision of the most senior solicitor, should compile and retain a record of material, legal, and ethical issues encountered as part of an annual learning and development record, and that this should be reviewed by the board or equivalent at least annually.
Well, Helen, whilst this protocol has obviously been produced with the commercial sector in mind, there is plenty in it for local authority lawyers to consider, and it may be helpful as a learning tool for senior officers and councillors alike in understanding the role of lawyers in local government. Now, turning to a fascinating employment case, if I say so myself. Listen to this. Sighing at a colleague at work. in frustration could be breach of equality laws, an employment tribunal has ruled. Non-verbal expressions of disappointment or irritation could amount to discrimination, a judge has said. Now, the ruling came in the case of a UK software engineer with ADHD who successfully sued a tech company for disability discrimination after complaining about his manager's sighing and exaggerated exhales. Robert Watson is now in line for compensation from Roke Manor Research, the inventors of the Hawkeye ball tracking system used at Wimbledon, in international cricket and in football.
Well, the hearing in Southampton was told that Watson started working for the company, I believe it was based in Romsey in Hampshire, as a software engineer back in August 2020. And the tribunal was told that Watson's timekeeping was poor, that he was easily distracted, and that he had some difficulties focusing. And this was as a result of his ADHD, but it wasn't diagnosed until November 2022, so over 2 years later. Now, I understand that Watson began taking medication after his diagnosis, and he took 4 days off sick. When he returned to work, the technical lead of one of the projects he was working on, who was referred to as DT by the tribunal, told him that he had to do several days' worth of additional work, partly because of his absence. Now, over the next weeks following that, DT continued to criticise him.
And Watson alleges that DT questioned his hours of work and his patterns of work at the time he spent at his project desk, and that he expressed non-verbal frustration, such as sighing and exaggerating exhales, the summary of evidence said. Watson went off sick with work-related stress from February 2023 and never returned. He filed his claim for disability discrimination in May 2023 and was sacked in January 2024. DT's behaviour towards him was found to be discriminatory by the tribunal. The employment judge at the tribunal, Catherine Rayner, said, "I conclude that the reason for the expressions of frustration arose from things which themselves arose from Watson's disability, such as his timekeeping and working patterns, and the fact that he was spending time away from his project desk." Had Roke Manor Research taken steps to identify adjustments required for Mr. Watson at an earlier stage and provided both him and the project lead with necessary support, then it is entirely possible that DT would not have suffered with such work pressure, and it's possible, therefore, that this discrimination would have been avoided. Now, other claims Watson made relating to disability discrimination and a claim of unfair dismissal all failed. His compensation will be decided at a later date.
Well, I imagine, Dennis, that this is all about context, isn't it? You know, what non-verbal cues were utilised alongside words and in what situation. I mean, body language is often the biggest giveaway of what a person really feels. It's an interesting one, and it's one employers need to give really careful thought to in their interactions with staff following this decision. Now, let's turn to family proceedings, and a spending watchdog report on family justice delays has called for a system-wide assessment of key issues affecting performance. Now, this is the National Audit Office's report, which states that complex accountability arrangements and limited information on the biggest causes of delays in care proceedings make it difficult to target improvements to where they will have the best effect.
Well, that's right, Helen. Some of the most vulnerable people in society are subject to family court proceedings. Delays in resolving cases can create additional stress for families, increase the risk of harm to children, and increase cost. Family courts have recovered better than Crown courts following the COVID-19 pandemic, but the family court caseload has declined by over 18,000 or 28% since August 2021. Despite this, the Audit Office state that children and families are still waiting too long to have their cases resolved. Now, as listeners will know, the statutory time limit to resolve most public law cases within 26 weeks has never been met nationally since it was introduced in 2014. And some open cases are nearly now 2 years old. Delays can lead to more delays as evidence or assessments need to be updated and costs grow.
Well, the reasons for delays are, of course, varied and complex, but the Audit Office states that departments do not understand which factors are contributing most to delays, meaning that targeting improvements is, of course, difficult. There's limited evidence on what works, but family justice partners are trialing a range of projects to resolve cases outside of court and to reduce delays, with some early improvements, it says, noted in some areas. However, some areas are still facing notable delays.
Well, the report concludes that there are several barriers that government must tackle to better manage the family justice system, including having good quality data, a system-wide assessment of the key factors that are driving poor performance, and a better understanding of costs.
Well, the Audit Office gives a stark warning. It states that until the government takes effective action to address these areas, its work to improve family justice will not deliver best value for money. And on that note, that's it for another edition of the podcast. You can read more on the items discussed today and many more besides by going to bulletin number 20, available on the LLG website. Now, so lovely to talk to you, Dennis. Goodbye from me.
Lovely to talk to you. And it's goodbye from me too. Bye now.